The Supreme Court just heard oral arguments in a case that could fundamentally reshape when police can enter your home without a warrant and potentially confiscate your firearms. And here's what makes this even more significant. This case is building directly on top of a prior 9-0 unanimous Supreme Court ruling that already told law enforcement they'd gone too far. But now, the Trump administration is asking the court to create what they're calling a sliding scale for warrantless home entries. Let's break down exactly what happened in these oral arguments and what it means for your constitutional rights. Before we dive into the details, I need you to understand why this matters so much. This isn't just about one case in Montana. This is about whether the government can use vague welfare check justifications to bypass the Fourth Amendment's warrant requirement, walk into your home, and seize your firearms. And the precedent set here will affect every single American's protection against unreasonable searches and seizures. The case we're talking about is Case versus Montana, and it involves a man named Trevor Case. Here's what happened. Trevor's ex-girlfriend called the police and said she'd received a phone call from him that gave her a bad feeling. When she and the officers arrived at his house, she admitted she couldn't actually remember what he'd said during that call, but she mentioned he might have a gun, and she was worried he might shoot at police if they entered. Now, the officers already knew Trevor Case. They had a history with him. They knew about his mental health struggles. 4 officers showed up at the house. They looked through every window they could find, trying to see inside. They didn't see Trevor anywhere. One officer noticed an empty handgun holster sitting out, along with a notepad. The officers knocked on the door. They shined flashlights through the windows. They called out for Trevor. No response. And here's where it gets interesting. During this whole time, some of the officers expressed serious concerns about entering the home because of their past interactions with Case. But others dismissed those concerns, saying Trevor didn't have the guts to do anything. After 40 minutes of standing outside, the officers made a decision. They tried the front door, it was unlocked, and they walked right in without a warrant. 2 officers went upstairs and one entered a bedroom where he saw a closet curtain suddenly jerk open. Trevor Case's face appeared, and the officer claimed he saw what looked like a black object. The officer fired, shooting Case in the arm, with the bullet passing through into his stomach. They handcuffed him, searched the room, and recovered a handgun they said was lying near a laundry basket. Trevor Case was charged with multiple violations, but his attorneys argued something crucial, that warrantless entry violated his Fourth Amendment rights, which means the gun and all other evidence should be suppressed and thrown out. The lower courts rejected that argument. The Montana Supreme Court rejected it too, in a 4-3 split decision. But Case didn't give up. He petitioned the United States Supreme Court for review, and they took the case. Now here's where we need to talk about that prior 9-0 unanimous decision I mentioned at the beginning. The Supreme Court has already addressed warrantless entries in 2 major cases. The first is Brigham City versus Stewart. In that case, the court established specific standards for when police can enter a home without a warrant under the emergency aid exception. The second case, and this one's critical for gun owners, is Caniglia versus Strom, decided in 2021 with a 9-0 unanimous vote. In Caniglia, the Supreme Court struck down what's called the community caretaking doctrine when applied to homes. Police had entered a man's home without a warrant, seized his firearms, and claimed they were just performing a community caretaking function. The Supreme Court said absolutely not. 9 justices, unanimous decision. They made it crystal clear that the community caretaking exception, which applies to vehicles, does not give police free rein to enter people's homes and confiscate their guns without a warrant. So Trevor Case's attorneys are arguing that the Supreme Court should apply the Fourth Amendment's probable cause standard to these emergency aid situations. They want the court to vacate the Montana ruling, which used a much weaker, reasonable suspicion standard instead. And they're citing Caniglia, saying the search wasn't justified under any exception to the warrant requirement. But here's where things get concerning. Both the Trump administration and the state of Montana are pushing back hard. They're arguing that probable cause should not apply to emergency aid cases. And the Trump administration specifically asked for something they're calling a sliding scale approach to reasonable suspicion in these situations. Think about what that means. Not a clear standard, not a bright line rule. A sliding scale that gives law enforcement more discretion to decide when they can walk into your home without a warrant. I listened to the oral arguments that were recently held in this case, and here's my assessment of where the court is headed. The justices focused heavily on one specific problem. The Montana Supreme Court didn't properly apply the Supreme Court's prior decisions in Brigham City and Caniglia. Instead, Montana used a looser standard, something even weaker than reasonable suspicion, and the justices were not happy about it. In fact, Justice Amy Coney Barrett directly called out the Montana Supreme Court's ruling during oral arguments. She used the word sloppy to describe their analysis. That's strong language coming from a Supreme Court justice. And from what I could tell, the majority of the justices, if not all of them, agreed that Montana got it wrong. They didn't follow the precedent, they didn't apply the correct legal standard. So the question becomes, what will the Supreme Court do about it? Based on the oral arguments, I see two potential outcomes here, and both involve the Supreme Court reversing Montana's decision. The first option, and this is what Justices Barrett and Roberts seem to suggest, is that the court simply vacates the Montana decision and remands the case back down to the Montana Supreme Court with instructions to properly apply the Brigham City standard. Essentially, they'd be saying, "You got it wrong. Go back and do it right this time using the correct legal test." This would be the more limited ruling. The second option is more expansive. The court could reverse and remand, but also apply the Brigham City standard themselves and provide additional guidance for lower courts nationwide on how to handle these emergency aid cases. If they went this route, the Supreme Court would look at Trevor Case's specific situation and determine whether the officers had an objectively reasonable basis to believe someone inside needed immediate aid. They'd set clearer boundaries and give lower courts a roadmap for future cases. Here's why this matters so much for gun owners and anyone who cares about the Fourth Amendment. This case impacts everyone's protections against warrantless searches. The Supreme Court now has an opportunity to either clarify or potentially expand upon those prior 9-0 unanimous decisions in Caniglia and Brigham City. And whatever they decide will have serious downstream implications for how much protection you have against warrantless home entries by police officers. Think about the precedent this could set. If the court allows a weaker standard, if they endorse this sliding scale approach, it creates more opportunities for law enforcement to bypass the warrant requirement. And when we're talking about emergency aid exceptions, we're often talking about situations that involve firearms, welfare checks, mental health concerns, domestic disputes. These are the contexts where police cite emergency circumstances to justify entering homes without warrants and confiscating guns. Now, I do want to be clear about what I expect to happen. Based on the oral arguments, I don't think the Supreme Court justices were interested in applying a strict probable cause standard to all emergency aid cases, which is what Trevor Case's attorneys were asking for. The justices seemed more inclined to either send it back to Montana or to apply the Brigham City test themselves. But either way, I suspect this could be another strong decision from the court, potentially even another 9-0 unanimous ruling in line with Caniglia and Brigham City, reinforcing limits on warrantless entries. That would be significant. That would send a message. And it would provide real protection for Americans concerned about government overreach into their homes and their gun rights. The bottom line is this: we're waiting to see how the Supreme Court will rule in Case versus Montana. This decision will shape the boundaries of the Fourth Amendment's emergency aid exception. It will determine how much discretion police have to enter your home without a warrant. And it will directly impact whether law enforcement can use welfare check justifications as a workaround to confiscate firearms without following constitutional procedures. This is a case every gun owner needs to be watching. This is a case every American who values their constitutional rights needs to understand, because the principles at stake here go far beyond one shooting in Montana. They go to the heart of whether your home truly is your castle or whether the government can walk in whenever they claim there might be an emergency. We'll be following this case closely as it develops. When the Supreme Court issues its decision, we'll break down exactly what it means for your rights. Because these rulings don't happen in a vacuum. They become the law of the land. They affect real people in real situations every single day across this country. The founders understood something fundamental when they wrote the Fourth Amendment. They understood that the power to search someone's home without a warrant is the power to control that person completely. It's the power to intimidate, the power to harass, the power to disarm, and they put strict limits on that power for a reason. Now it's up to the Supreme Court to decide whether those limits will hold or whether they'll create new exceptions that weaken our constitutional protections. Stay informed, stay vigilant, and remember that the rights we don't defend are the rights we'll lose.